Well, good morning. My name is Richard Ponte, and I'm the Director of Events and Programs for the Maine State Chamber of Commerce. On behalf of the entire team here, it is my pleasure to welcome you to the debut webinar in our series on employers navigating immigration and workforce compliance. Today's focus will be on Form I-9, the basics. Thank you for joining. Before we get going, there are just a few things we'd like to share with you about today's session. All participants are in listen-only mode. Please submit questions using the Q&A function. Time permitting, we will answer them by the end of the session. We will also use the Q&A feature to share useful links and other materials. We have enabled closed captioning in English. You can access this feature by toggling it on the taskbar at the bottom of your screen. And this meeting will be recorded, as will all the episodes in this series. We will make sure the recordings are available to you on our website upon the conclusion of the series. And finally, if you lose your connection, please use the same Zoom link to reconnect. We would now like to begin by thanking our sponsors. Our 2025 webinar series sponsors are AARP, Bangor Savings Bank, Hennebeck Savings Bank, MEMIC, Merrill's Investigations and Security, Northeast Delta Dental, and Summit Natural Gas of Maine. It is now my pleasure to introduce the President and CEO of the Maine State Chamber of Commerce, Patrick Woodcock. Patrick will be moderating the conversation today. Good morning, Patrick.
Good morning, and thank you all for joining us. This is a continuation of a presentation building on the fundamentals of a description of best practices for compliance with immigration requirements. You don't have to be an attorney specializing in immigration to reflect that there are a lot of changes occurring. Just this past week, we've had a Supreme Court decision on the temporary protected status program. And every week there seems to be additional changes for compliance. This is the right time for employers to examine best practices, to examine how they are ensuring that they have compliance with the protocols required and that they are prepared for any future changes for immigration requirements. Employers are constantly trying to navigate new state, federal standards, and it is imperative that HR and business leaders understand these dynamics. We're very pleased to partner in a webinar series to look into the objectives with ensuring compliance. We have an expert who leads Pierce Atwood's immigration practice group, and Katie Minervino, who joined us in February, has agreed to participate in this ongoing series. I'll turn to Katie to begin our discussions on the I-9 fundamentals, which really does underlie the foundation of best practices for immigration status. Katie?
Thank you, Patrick. Thank you, Richard, and thank you everybody for joining today. This will be the first of a four-part series. This is intended to provide a basic overview of the Form I-9. In the next session, next week, we're going to talk about more advanced issues, and I'll kind of like touch on a few of them and probably say this will be a next week's session as we're going today. And then we're going to talk about considerations around hiring foreign workers and then preparing for if there would be any type of enforcement on site for the I-9 and relating to other types of immigration enforcement. But we're kicking it off talking about the Form I-9, and the Form I-9 I think is very interesting. I think you will kind of appreciate as this goes on. a big nerd around this, but it's not an issue for employers who are sponsoring foreign workers. This is an issue and a requirement for every employer in the United States to make sure that we have, as a country, a lawful workforce. So this is intended, and the whole series is intended to provide information and support and kind of enhance compliance. That's the goal for all of this, to make sure that employers in Maine and elsewhere have the tools that they need to be able to follow the rule and reduce risk relating to it, from all sides. So the Form I-9, I was preparing the PowerPoint, and I know there is a way to like, kind of like add things that jump out. I couldn't figure it out. And the things that were kind of crossing my mind in terms of what to add, are the Form I-9, everyone's favorite millennial. It started in the 80s. The Form I-9 over the hill, going to be 40. Form I-9 is still relevant. I'm over 40. But probably as you can kind of see kind of a good thing that I didn't pull this off, but that's kind of the tone, and it's the way I think about it. It's kind of like, the 4x9 is, kind of like me, kind of middle-aged millennial trying to like struggle with evolving technology, and that's, kind of where we are. So we have, an I-9 form that began in the 80s. I'm going to go through the timeline. This was required since 1986. And when, I'm thinking about it, and I'm kind of joking around, the development of technology, but, one of the themes, that will, kind of carry through both the I-9 presentations is, this was kicked off in a very, primarily and exclusively paper-based format, and it still is a paper form. However, over the past almost 40 years, a lot of us have lived through and, kind of seen the development of the internet. In the workforce, a lot has moved from being paper-based to electronic. In our lives, a lot has moved from paper to electronic. My kids can't believe when I tell them things like, I hand wrote my college application. Where, kind of we've lived through and we've seen that shift, and that the I-9 is not in any way, kind of isolated or immune for it. In fact, kind of that's been a big piece of where we are today relating to the form, employer options and compliance, and where we're going. Are we at some point going to, retire the paper form and move to an electronic database? What would that look like? That's probably a session 2 topic, but kind of that's the kind of the theme that we're going to be thinking about and working from. So the Form I-9 Basics, it's a form that is, kind of managed and produced from the Department of Homeland Security, and the current version is posted on the USCIS.gov website. And this is a very important bookmark to double check and to post for the I-9. And it's kind of your landing page here on the USCIS site where the government posts the current version of the form and the current form instructions. So, no matter kind of what method you complete the form, if it's paper, if it's electronic, it's very important. It's a good practice to check this website regularly just to make sure that you have not, kind of created a situation where you're completing the form and you've missed an update to the form. We're going to talk about the importance of using the current version over the course of this presentation, but the government does update it regularly, and it's a violation if you use the old form version. So you want to be, kind of checking in to make sure that you have not, had a situation where you printed, 300 Form I-9s and put them in a folder, that you grab on site, or that you might be working with an electronic vendor, that is missing some important update on the form. So, it's very important to track and just to reference this website, and that's where the form is posted. So to, kind of go through the beginning and to kind of like take a stroll through the history of the Form I-9, the key dates, this started in November of 1986. With the Immigration and Reform and Control Act, the Form I-9 is required. So you need to have, as an employer, an I-9 on file for any employee hired on or after November 6, 1986. So again, here we are, kind of coming up very soon on 40 years. The form carries penalties for noncompliance, which we're going to talk about also in this presentation. But the regulations outline penalties that are now updated regularly based on the Federal Civil Penalties Inflation Act of 1990. So the practical impact of that is that if you came up through human resource training or kind of had an early training on I-9 for a very, very long time, the range of paperwork penalties ran from $100 to about $1,000. That was kind of the low and the high end that you could be liable per form. As a result of the application of the Civil Penalties Inflation Act, since 2015, on the regular now, the government publishes updates in the Federal Register, which kind of bump up the possible liability for the penalties. So you are, if you're thinking about, kind of what you could be, kind of exposed to in terms of having fines from the government for noncompliance, it's more than double that now. I have the numbers on a future slide, but it's the money's real relating to it. And the form has always been paper. It's been a paper form. You can create it and retain it electronically, but it's a paper form. And the idea is that you sit down with your employer and you look at their documents. And there was a very significant shift during the pandemic that kind of resulted from the inability for people to be in close physical proximity, that for a period the government said, we get it, it's not acceptable to be within 6 feet, and if you are within 6 feet you're probably going to be masked. So there was a temporary flexibility that you could defer the physical in-person inspection of documents, and that was a big deal, because the requirement has always been that you are reviewing documents in person and touching them. At the end of the COVID period, the government looked at this and said, all right, this worked okay, having some documents that were reviewed not in person physically, but in a virtual or alternative method. And the government posted a new rule that allowed for an alternate option to be available in lieu of the physical in-person inspection. That's going to be a topic we dig deeper into in the second presentation, but there is the ability now to do the I-9 process for, in particular, remote workers, if you meet certain conditions where you are doing something like we are today. We are on video. It would, involve me, sending my document copies ahead of time, putting them up on the screen, you as the employer looking at them. But that's a big change, and it is a benefit for a lot of employers that have a primarily remote workforce. And that's it's something we're going to talk about in a little bit today, but a lot in the next section. So what's at stake? Why have you given us, an hour and a half on a Thursday morning to talk about this form? Employers who violate the law are subject to possible civil fines and also criminal penalties if there's a showing of a pattern or practice of violations. So there are, there are consequences for not completing the forms, completing them correctly, or having a pattern of violations that could make you subject to criminal penalties. Employers who have I-9 violations may be debarred from government contracts. The government may intervene, and there might be orders for back payment if an employer discriminates against somebody, and that's easier to do than you might think. We're going to talk about that today. And you also might have to go back and hire somebody if an employer discriminated against them. And as I kind of got all worked up in the last slide around the penalties, the civil penalties for I-9 paperwork violations now range from $288 to $2,861 per form. And those fines are assessed for violations that occur in the current fine range validity period. So they've, kind of been staggered. But one important thing to note is that the occurrence of the violation is at the time that the government assesses the violation. So if you have forms that have penalties, even if they were created a long time ago, if you haven't had a government inspection and there hasn't been any indication that there was a violation previously, then you are going to be subject to the higher fine amount. So you are going to be liable for this range of penalties, even if the error was made in the past. So it's very important to clean up errors and try to kind of lock in, the period that you would be liable for the higher penalties by correcting them. And then also there's a statute of limitations for the I-9 penalties that you can, sometimes take advantage of. It's 5 years. So, if you were to, if the short of it, another way to think about it is if you were to get a notice of inspection now, you would be liable for each form for paperwork violations that range from, almost $300 to almost $3,000 per form. And if you have 100 forms, wherever you end up in that range would be times 100. So there really is, potentially high financial liability at stake here for the forms. And it's it's, you know, kind of worth the attention to get it right, you know, so that you can, you know, kind of like eliminate, you know, mitigate, reduce that risk for you as a company. And there are civil penalties for knowingly hiring, recruiting, and referral and retention of unauthorized aliens. You know, that's the language in the statute. And they range from 700 to 28,000 per individual. You know, and that's a very high, you know, top number. And the range is run, you know, for multiple infractions too. You know, so that's going to be your highest. But again, that's a lot of money. So as I said, this all relates back to the Immigration Reform and Control Act. You know, it's often referred to as IRCA, IRCA, if you see that. And the core requirements of that law are verification of employment eligibility. You know, every employer is doing this, and it's not just individuals who are not born in the United States. Every employer needs to do an I-9 and verify the employment of all of their employees, including U.S. citizens. In doing this, you're not allowed to discriminate based on citizenship or national origin, and there's a prohibition against retaliation in the process. These rules apply to everyone hired after November 6, 1986, and every employer is covered along with certain entities that recruit or refer for fees. You know, so this is, you know, this is everybody. You know, this is not, you know, if you sponsor workers, this is something that runs to everybody, and you know, everybody is at risk for getting a notice of inspection and, you know, possibly having to turn your forms over. And it's, you know, there's the paperwork piece of it, and there's also the people piece of it. You know, so the idea here is that you're doing the forms, you know, and you're liable for penalties and assessments if the paperwork is not done or not done correctly. You're also liable if, you know, as a result of, you know, kind of not doing the forms, or, you know, kind of like poor completion of the forms, you are hiring individuals who don't have authorization to work. You know, so employers that have, you know, very, you know, kind of like very kind of frankly been deputized by the federal government in terms of ensuring that we have a lawful work authorized workforce, that all of the people who are in the United States working for them have the authorization to do so. You know, so you, from the employer standpoint, who are responsible for the forms, you are the gatekeepers for our authorization for our workforce. And I also, another thing I did not put in, but I thought about, because I was kind of like in a 1980s thing, I was like thinking about doing a graphic from Ghostbusters. When they were the gatekeeper, but I did not, you know, kind of go too deep into my 1980s you know, kind of graphic theme. But that is, you know, kind of that's how you should be thinking about it. You know, as the employer, you know, it's important that you get the paperwork right, because they may fine you on the forms for not doing it. But it also, you know, it ensures that the people who are working have been checked, and that their identity and their work authorization have both been verified. And that's, you know, that's the employer's deal. You know, that's how this whole process works, and that's why we do it. And you know, that tracks through the basic verification process. You know, step one, the employee completes section one. You know, the form is, you know, kind of, it's a collaboration. You know, there are steps, and there are, you know, kind of responsibilities, and there are signatures, and there's compliance for both the employee who is starting to work and the employer. So you have step one, the employee starts, the employee kicks this off. The employee gets the Form I-9 and they complete section one. You know, they say, this is my name, this is my contact information, this is my address. They will attest, you know, to the type of work authorization they have. I'm a US citizen, I'm a lawful permanent resident, I'm authorized to work. You know, that's the section on the form that has the checkoff boxes. And then, you know, the employee then signs under penalty of perjury. And that's a big deal. You know, you are signing under penalty of perjury as an employee that the information in the form is correct. And the government cares, you know, around that signature. There's a, you know, kind of a key component of all of this, that there's an attestation made by the employee. And there are ramifications that extend beyond just even the Form I-9 compliance. So for example, if you are in the United States and you are not a US citizen, and you claim to be a US citizen, you are breaking an immigration law, and it's a very serious one. So for example, if you have somebody who completes the form and checks the box and says, I am a US citizen, who is not, that's a, you know, that's a violation of that law. And they are signing under penalty of perjury that's correct. So the government, they care about the signature. You know, we're going to talk about that, you know, kind of in more detail when we get to the next session about, you know, kind of electronic I-9 forms and the vendors. But, you know, who did what and when, especially for the signature piece of it, is something that the government cares about, and wants to make sure that it has the veracity and the ability to see it. In the paper form, it's the wet signature. They're on that, and you can track to see who signed it. So the employee does their thing, and then the employee presents documents. So I am the new hire. I complete my form, and then I come to you as the employer, and I say, here is the documentation that shows who I am. You are verifying my identity, and also that I am authorized to work. That's the premise. And that runs to everybody. That runs to US citizens, that runs to people who have temporary work authorization. It's the same regardless. So you can't hire somebody and have them working, even if they were born, kind of in Maine, even if you've known them your whole life. Everybody's required to be verified. This is who I am, and this is how I'm authorized to work. So the employer, they look at the documents. There's kind of a piece of it that the employer looks at the documents, and then based on that record, they complete section 2. The employer also sends in a penalty of perjury. The employer is then saying, like, yes, it's like, I have looked at it. I have confirmed this information. I am, filling in the form based on the information that the employee gave me. I am signing off, and then that completes the process unless there's verification required. We're going to talk about that, but then that completes the form. You've got the form on file, and then the employer retains it. So you don't file these, you don't send them in, you don't kind of do anything with your forms. You keep them on file, and then they're not a thing until they are a thing. Usually when they are a thing, the government is coming on site and saying, like, I would like to review your I-9s. So that's really kind of where the rubber hits the road, where the government is coming on site and saying, you have this obligation, show me the paper. Show me how these forms, show me that, first of all, they were completed timely, and that you have done your thing and the employee has done their thing, and all of the sections in the form that need to be are completed correctly, and that they are on file for the government to take a look at. And that's the piece of it that would result in the fines. So the key definitions in the concept on here is hire. We talk about completing the I-9 when someone is hired. It's the commencement of employment for wages or other remuneration. So when you think about that, you can't have somebody that's working for you that says wages or other remuneration. If they don't have work authorization, you can't say, oh, okay, well, I'm not going to pay you now. I'm going to, not give you your salary, but I'm going to give you housing. If there's some quid pro quo, and this is work, and you've hired them, that's the starting point. This is the point where you are starting to work, you're starting to get paid, and that's the key kickoff for all of this. Employment defined by reference to the multi-factor control test. A lot of the people on this call are probably like wearing multiple hats in HR, kind of like legal, kind of compliance for companies. So the idea behind here is similar to when you're thinking about classifying individuals for purposes of other benefits and employment law considerations. Are they an employee, or are they an independent contractor? So the idea here is also, you can't have someone who doesn't have work authorization and say, oh, I'm not responsible for the I-9 because they're not my employee, they're just my contractor. So they're going to do their thing. If the government comes and looks at it and says, like, no, they are working for you. You can't just call them an independent contractor and pay them on a 1099 to skirt the requirement that you, as an actual employer, are verifying their employment authorization and doing the form. That also works to your benefit, though. If you have a bona fide independent contractor, you are not responsible for verifying their employment authorization. So if you have someone who's working for a different company and that you're contracting with that company, that's their employer's deal to re-verify, and you're not liable for unauthorized employment. That is not, kind of like a blanket rule always, because if you do get knowledge that somebody is working for you as a contractor, even if you're not responsible for doing the I-9, you may be liable for knowingly hiring or having somebody work with you if you do in fact know that they're not work authorized. So again, kind of that's going to be fact specific, but from the paperwork standpoint, you are responsible for doing I-9s for somebody that you hire, you employ. You are not permitted to kind of like do other activities like kind of recruit, refer if you know they're unauthorized. And that kind of the whole idea behind here is, like, one, you're not allowed to employ, recruit, have people on site if you know they're work authorized, and two, you have to do the paperwork. So you're kind of like, it's like I said, it's the paper and it's the people. There's kind of like, they work together, and that's kind of that's what we're doing. That's the Form I-9. So at the point that you are doing the Form I-9, and this can occur after the acceptance of the offer, and the Section 1 has to be completed by close of business of the hire date. The employee has to do Section 1. We talked about, and I told you all about the penalty of perjury. You're checking one of those boxes and you're acknowledging, on the form, there's language on the form. And if you're using an electronic vendor, the regs actually say that electronic vendor, when you e-sign it, has to have some type of like acknowledgement of this language that lives right above the signature box. So a lot of vendors will have kind of like a pop-up that you check off. But the idea is that, kind of like I'm the employee, before I start working, this is, kind of like on my first day, I am coming to you and I'm saying like, yeah, I'm good. Like, yes, like, I'm not authorized to work. I'm telling you that, and I'm signing that under penalty of perjury. Kind of you have a little bit of flexibility in terms of when it gets done. You have to accept the offer. You can't just start having people do I-9s if you haven't made an offer of employment to them that they've accepted, but you don't have to wait until the first day if that offer has been made. So a lot of times employers will have somebody like, kind of like send them their new hire paperwork ahead of time, kind of like the signature and the date can precede the actual first date as long as the offer of employment has been accepted. And I'll mention this. This is a basics presentation, and this stuff's confusing. It shouldn't be, frankly, it shouldn't be this hard for all employers to have to do it. I think, and I work on the I-9 a lot. And there shouldn't be that many questions. There shouldn't be that many issues if everybody is supposed to be able to fill out a one-page form. But, kind of a lot of times when you hear about the I-9, the timeline that's communicated is it has to be completed within 3 business days from date of hire. And that's true. That is the overall overarching timeline for the I-9. But if you're taking, kind of kind of just one, kind of key concept away from this also is that like, yes, but the employee doesn't have that whole timeline to do Section 1. There's kind of a staggered timeline in play here, where the idea is that like the government doesn't want people to be able to work and be paid and then check in like 3 days later and be like, you good? And then they'll be like, no, like, so you're asking the employee like at the very outset to sign off. So the first step, Section 1, has to be done by the end of close of business of their hire date. The hire date that's filled in on Section 2 by the employer has to be the same date or a later date from when Section 1 is completed to be able to have the I-9 timely completed. And then the employer is attesting in Section 2. So at this point, you're having the employer look at the documents, examine the documents, record the information. They're also attesting, that they have looked at the documents, they appear to be genuine, relate to the employee, and that to the best of the employer's knowledge, they are authorized to work. So we talk about the I-9 and we talk about there being possible fines, compliance, all of this, and it sounds like it's kind of like, and like, I don't know, I talked about Ghostbusters and the gatekeeper, like, but this is ultimately also a benefit and a form of protection from the employer also. Because if you are doing the form and you're doing it correctly, you have a rebuttable presumption that you have, no liability for the unauthorized employment piece of the I-9. So if I'm the employer and I did the form and I had the employee fill out Section 1, I did Section 2, they gave me a fake document, but it was a really good fake document, and I did my piece of it. I filled everything in. I looked at the document. I met that standard. Then I'm not liable. It's not my deal if somebody's working, on fake documents and working without employment authorization. That's an individual violation for that employee. However, I'm covered because I've done my part. I've done the form. So the importance of compliance runs in a few different directions, and one of them is kind of squarely in the category of it's important to get it done and to do it right, because you are providing very important legal cover from your organization for completing the form and verifying the form in the process that's required by law. That you have that protection from the employer standpoint. And when you're doing it, it's a relatively low bar. Your standard is reasonableness. You, as the employer and the person completing the form in Section 2, are not required to be a document expert. Your standard for looking at the document is reasonableness. You're not, when you sign it, like I said, you're not attesting the legitimacy. You haven't like, kind of like gotten that document and, done any type of like extra, like, kind of like crazy like verification. You're taking the document and your standard is that I reviewed the original document. It reasonably appears to be the person, and it reasonably appears to be genuine and relate to that person. So kind of your standard, like, does it reasonably appear to be genuine? Does it look like they made it in their garage? Does it make sense? Does it have somebody else's picture on it? Does it relate to the person? Like how kind of like how far are we from what this looks to be the person that you are either kind of doing the process, sitting down and looking at like in person, physically inspecting the document and the person, reasonable standard. People change, people get bangs, people, people cut their hair. Like that's all okay. Does this reasonably appear to be genuine? And that's why the alternative process or the alternate virtual review that's in place now, it has, in this like longer term piece of it, it has a video component, because the whole idea is that like, okay, if I have documents and they got a copy of it and then they're presenting it, like, does this pass muster, with that reasonableness standard that the documents that you gave me looks like the person that I'm hiring, and that's where the employer has to draw to, kind of really draw that line. So for the I-9, we talked a little bit in the very beginning about using the version in effect at time of hire. So you want to make sure that you're using the current version. It is a violation if you're using prior versions, and use the current version for any re-verification. So it's, kind of like, it's also worth noting that like sometimes stuff shifts, when you're doing this. So maybe you were doing I-9s, kind of like 10 years ago, and you're doing the form and it was a 2-page form. The newest version has reverted back to 1 page, so now you're back on the 1-page form. And there used to be section 3 of the form where you would like re-verify. So if I give you an employment authorization document expires next month, you have to come back to me and say like, okay, your work authorization expired, can you keep working? Show me proof of that work authorization. That's the, kind of the re-verification piece. Now the re-verification is done on the new version of the form. It's called Supplement B. So now you're like, oh, like, for Pete's sake, I thought I had it all figured out with section 3. Now I have a Supplement B. If you're doing a re-verification and you have the form, you go to the current version and you get that Supplement B and attach it to the form that you initially completed. So you're, going to be continuing to check in on the USCIS.gov site. There's the M274 handbook for employers. That's a very important resource. It covers a lot of contingencies, like, what do I do about, certain classifications? I need more guidance. I'm going to check it. I check it all the time. Like I think I might know something. I go back and see like, well, what's in the instructions? How do I like, kind of phrase this? It's a, kind of very important resource to be able to use. And again, it's a little bit annoying because it used to be posted and it used to be able to be like downloaded in a PDF. And whenever they updated it, they would like create a new PDF and they do kind of like a little like, record of what changed. They don't do it anymore. Now it's all online. So you can't really like print it out and like put it in a drawer or a file for your managers who are completing the form. You really do have to go onto the website and kind of like navigate it. So it feels that M274 has kind of like taken more of the feel of this I-9 Central, which is also a resource that the government kind of put up. But, they're both, at this point, information that's available on the USCIS.gov website and is intended to address situations that come up and provide, more instructions, more example for the form. And they are both at this point kind of for better or worse, kind of dynamic. And I, in talking through this and thinking through it, I'm going to go back to one slide in terms of what the employer is responsible for doing and reviewing the documentation, because I jumped over this, but I want to make sure this is super clear on this presentation. When you're doing the I-9, you are verifying the identity and the work authorization of the individual. And I know I've said that, several times now, but it makes sense then, because if you look at the section 2 of the form and the instructions, there are these like lists in these columns of the documentation that you put onto the form and that the employee can present. List A, those documents are documents that by their nature verify both the identity and the work authorization of somebody. It's a one and done. They're kind of like two birds, one stone. If I give you my US passport, you can see who I am and that I am a US citizen. So I only need to, and you only would complete list one. Kind of like that's kind of both identity and verification. Or alternatively, you can have employees, kind of choose to present one document each from List B and List C. List B documents, they verify the identity of somebody only. So you are, kind of showing documentation which shows who you are, but does not necessarily mean that you are authorized to work. So if I provide, for example, my main driver's license, that shows who I am. It has my photo, it has certain pieces of information that, has my name, the picture, some bio data. But you can get a driver's license or state ID card in, kind of like many states, even if you do not have, work authorization. The list B documents, they show who you are. The list C documents show that you are employment authorized. So if you are presenting a US birth certificate, that means that you are a citizen, so you are work authorized in the United States. Like a social security card that is unrestricted, that does not have language. The restricted language on the social security cards that don't work, say, valid only with DHS authorization. That's a restriction, so that does not work to show that you have work authorization. But that's why there's that combo. List A is, identity and work authorization. B is identity, C is work authorization. And you want to be, kind of you want to be firm with that. You don't want to start mixing and matching and putting more than what's required, or even just if people present documentation to you, like, kind of like just being, "Oh," kind of like, let me write it all down. It's, for the form, it's one or B and C. So that's a very key concept here. And we're going to talk a little bit about discrimination in a couple slides. But I wanted to run that back because I had jumped over that. So, when must the process be completed? We talked about this, kind of within 3 business days from the date of hire. That's the full I-9 completion date. However, Section 1 has to be done by end of close of business, the first date. And these are business days. So if you are, an organization that is, kind of like hiring somebody on Friday and you're closed over the weekend, you don't count Saturday and Sunday. And when the government has been clear, and this is a little bit confusing, that if you are hired on Monday, you have until the end of close of business on Thursday to complete the form. So you have, kind of the end of 3 business days after the date of hire. So hired on Monday, you can do it by the end of Thursday. That does not mean that you have to complete it. Kind of within that period, a lot of employers will do it on the first date because they are sitting down and they are, kind of like meeting with the employee. But if you have somebody that comes in and does Section 1 and says like, oh, I forgot, I didn't bring my documentation, they have a window to do Section 2 with you and to complete that form. There are some situations where, kind of you do the form initially and it is not the, kind of the end of the story. One of those is if you have someone who's work authorized and presents a qualifying receipt, like my passport was stolen, my passport was destroyed, but I have applied for a receipt for it. The government says like, okay, we'll take that receipt, but we're going to give you 90 days. At the end of that 90-day period, like, kind of come back. So it, kind of it allows some flexibility if the documentation is not available for some reason, because at the end of the day, we want people working, right? Like, this is not intended to be some type of like gotcha or like don't work or like just forget about it because you don't have it. There is that flexibility if you have somebody who's work authorized that like life happened and they just don't have the documentation to do the receipt option, but it has to, follow the rules. There's instructions in M274 and how you record, that this is a receipt, and then you would need to calendar that follow up and check back in and, kind of meet with the employee and take action so that you can have, kind of proof of work authorization. It doesn't actually even have to be the document that they presented the receipt for. The discrimination piece of it is a very, kind of interesting component for the I-9. And it's one that I think is really important to talk about here. And it's one that I find very challenging, around the I-9 process and, frankly, kind of frustrating sometimes. And I'll tell you what I mean for that. So, there's one, like the really obvious prohibition about discrimination is if somebody's authorized to work, you cannot discriminate against them, because of their national origin or their citizenship status. And everybody is protected from national origin discrimination. So you cannot say like, I will not hire somebody that is of a particular country. I don't like that country. We're not going to hire somebody born in country, kind of X, Y, or Z. Not allowed to do it. You also can't discriminate. You can't say like, I don't know, like I did this presentation and like I'm like real stressed out. So you know what we're gonna do? We're only gonna hire US citizens. No, that's easy. Like, like why would like why not just like zero out any like, need for re-verification or, kind of like dealing with anything I find confusing. Like we're just gonna hire US citizens. Like, no, there are US workers, and you think about, kind of when you think about who's protected against, kind of citizenship discrimination and under these laws, your US workers are not just citizens, they are lawful permanent residents, they are asylees, they are refugees. Those are US workers, and there are other people who have work authorization that carry, other considerations around like you're not obligated to sponsor somebody, and this is going to be a deeper dive, especially in section 3 of this presentation, when we talk about what it means, to hire somebody who's not, a US worker. What are your requirements? What are your rights? What are your obligations? We're going to talk about that. But, kind of like easy prohibition against discrimination is the concept of like, no, there are some jobs and some laws that say you must be a US citizen to hold them, and you are allowed to, kind of enforce and abide by them, but you just have to be really clear that you're getting that right, and you're not like imposing a citizenship only requirement where it's not supported by law and fact. So that's, kind of that's kind of one standard that I think is probably intuitive to everybody. The other thing here is that employers cannot specify which documents they will accept from an employee. And this is, kind of this is something that is very important. The Department of Justice Immigrant Employee Rights Group is an agency for the government, and this is something that they focus on a lot, and that's, kind of very important to them. And it's something that it's a little bit easy to get wrong. So if you are thinking like, oh, like, I did this, this presentation. This is like very tricky. So like, I'm going to make it really easy because I think, most people in Maine probably have their, kind of their driver's license and either their birth certificate or their social security card. So I'm just going to say everybody that's, kind of like everybody that's being hired here, just give me that B&C document. Like that's going to be easy. Or like, kind of like I'm going to make my life easier and I'm just going to say like I want you to show me that you have a US passport. Like, you like this is what we're going to do. That is, against the law by specifying what you have to give. So you want to be really clear, even if you think that you are making it easier for the employer and the employee by saying, give me this, you can get in trouble for that. So, kind of double check your language. So if you are sending, if you have somebody who has accepted an offer and you're sending them the form, and the instructions, make sure your cover letter where you're saying that does not say on the first date of hire, be prepared to present your US passport or like, any particular documentation. You want to be very, very clear that it is the employee's choice which documentation they present that is valid for I-9 purposes. That's something that like you might be thinking like it's helpful by saying like just give me this or just give me that. Even in a re-verification, the language that you want to use in a really important takeaway is just like it's your choice. I will accept any documentation of your choosing valid for the I-9 purposes. You tell me what you want to give, and then, kind of start from there. And again, if you take, kind of really like besides like the timeline for this basics course, one really important thing to take away from here is when you're doing the process, as part of the form, and it's actually like it lives in the form, it's not in the instructions, there is a one pager that says list of acceptable documents. And it has, kind of a table and it has categories of documents that are listed, list A, list B, and C. You want to make sure that you give that piece of paper and that list of acceptable documents to your employees that you're completing the form with as part of the process. And you say, here's a list of acceptable documents, your choice, and then go from there. Because there are going to be situations where, kind of like it's a little bit confusing. There might be a conversation, they might ask for help, they might ask for clarification. And I am not suggesting and saying like you can't tell people what they're allowed to present and, that we have to, if you get a question, you have to just like refuse to answer, don't engage. Like you could have that conversation, but what you want to do is you want to start with the communication that is, here's the list of acceptable documents, your choice, 1A or B and C, we'll take anything and then go from there. And at the same point, kind of relating to this too, you can't require more or different documents in those. So if you have somebody who, kind of presents a document that, kind of like you just don't feel like dealing with, like, no, you can't say like, oh, like, I don't know, like, like you gave me B and C, but it's easier for me to just do A. So, kind of like come back and do this. Or you can't say like, oh, kind of like this worker, like, I'm just not sure. So like, yes, they gave me a document that reasonably appears to be genuine and relate to them, but like, I'm going to be extra good in terms of my verification. And I'm going to ask for not just A, but also B and C. There's no extra points for, kind of like over documenting. In fact, it's illegal. So you want to be very clear, that you're not going to do more or different documents than what's required. You're not able to do that. And you also want to be really careful then, when you're completing the form, that even if they give you more documents, don't write down more than what's required, because even if it was their choice, and this is, kind of like in the space that, kind of like we work and we're doing presentations, we kind of like affectionately refer to this. And a lot of people have probably had the situation like the purse dump. Like I come in, like I'm doing this and I'm like, all right, like, here, like, I don't know, like, I just like, I dump out my purse, I dump out all my documents and I'm like, like, here's my license, here's my passport, like, here's you choose. And then you're just like, oh, so she like I gave you my license and my passport. So you like, she gave them to me and I want to do a real time recording of what she gave me. Because what if one was good now or not good? Now I have both of them and I put them down. In hindsight, if anybody looks at that form, it's going to look like you've required more than what's required because you wrote down more than what was required. You're not like, the person reviewing that is not going to have the insight that I, kind of gave them to you. There's going to be a presumption that you asked for more because you put them in. So you want to be very, very thoughtful, around, kind of like how you complete the form. And if you're in that situation, just say like, listen, thank you for giving me all these. Here's the list. Like this really has to be your choice. Like, here are the combinations. Like, what do you want to use? Have them give it to you and then write that down. That's a very important component to completing the form. Kind of you want to be careful. It's a little bit nuanced if you have somebody coming on site and I offered them, a position, and then you get, kind of a document and it has an expiration date and you're just like, oh, for Pete's sake, like I don't know, like, like you want to, kind of like that's something that you don't want to just, kind of like out of turn at that point, say like, kind of like see you, like we're not going to re-verify this. Like that's something that you want to be mindful about. And that's the scenario that we're going to talk about in session 3 in particular. And, kind of unnecessary verification may also violate the anti-discrimination provision. So, the I-9 is really supposed to be one and done. Like you're really not supposed to be like going back and like redoing it and redoing it and redoing it. If you have errors, and we're going to talk about that, or there's a lapse, like, yes, you may go back to the employee to correct it, but you want to be mindful, of, kind of like over verifying, because that results in you asking for more than what's required. Like you've done it once, like, if the form's fine, like why would you go back and do it again? You want to be, thoughtful, around, redoing the form. And I will, there's just one question in the chat. I'll just really quick. It says, do you need to keep I-9 forms on the site of work being done, or can our HR manager, executive director store these files offsite due to space and security issues in the office? They can be stored offsite. Like, so the kind of the forms can be kept anywhere. What's the best practice is to kind of treat the I-9 separately from other pieces of, paper or, kind of documentation that you have, and not just slot them into somebody's personnel file, because the form I-9, it is the piece of paper, but when the government asks for them and, kind of like under the rules, the form I-9 is actually like the form and all the documents attached to it. So if you have document copies, if you have proof that you did e-verify, your form I-9, kind of like if you have a file memo around the form, you should think of your form I-9 as kind of like any documentation that is kind of bundled with the form. And if you keep the forms with personnel files, if the government comes on site, then you're kind of like, arguably you'd have to turn over the whole personnel file because they were attached to the form. And for purposes of retention, purging when they're not required to be kept on site anymore, tracking re-verification, it's just a good practice to kind of keep them separate. So it's easy to, kind of manage your I-9 separately from other pieces of paper. So your best practices, you present the employee the instructions and list of acceptable documents. Like that's the starting point. Like, these are the rules, these are the instructions. Like, it's the Form I-9 world we're just living in it. Give them the form, give them instructions, give them the load. Kind of go from there. Understand that the list of acceptable documents is not a finite list. So I was, very intentional when I talked about the list of acceptable documents. And I said, the list of acceptable documents lists categories of documents. So there are documents that are acceptable for the Form I-9 that do not appear on that piece of paper. One of one of the I almost put a heading like, why is the load so heavy? I know what but the idea is that the list of acceptable documents talks about categories of documents. And for example, in the list of acceptable documents, there's a bullet that says employment authorization document issued by the Department of Homeland Security. And that is kind of a catch-all, and that's intended to be kind of broad. So then if you kind of like dig deeper and you go on to the M274, the I-9 Central, you can see examples of things that are employment authorization documents that are, I think of this as the lowercase employment authorization documents, not the EAD card that's the list A, but like employment authorization documents that live in that category of documentation. So for example, a naturalization certificate is posted on the website of an employment authorization document that's not specifically called out on the form, but is, acceptable for the I-9. It's intended to be kind of broad because stuff happens, as Patrick, aptly kind of like teed this up, there are a lot of changes, in immigration, presently and on an ongoing basis. And the government actually wants to be able to kind of like respond and react, and kind of like allow employers to use documentation and not kind of like, pigeonhole every single document on that piece of paper. So when you're, kind of giving that list, it's like I said, it's kind of like the jumping off point. You may be in a situation where the employee saying like, this documentation is valid and you need to, kind of like go back and check, and I almost had on this list trust but verify, but I didn't know if that would be confusing. If you look at the presentation, you're just like, no, we always verify. We don't just trust. So, but when I was saying trust but verify, I was actually thinking of myself, and for you. So you're like, if you have an employee that's saying like, I'm employment authorized, like I think that this can work, kind of like don't dismiss them out of turn if you're not entirely sure. Kind of like if somebody's saying like, I have a document and it's one that you're not familiar with, or even if you look at that list of acceptable documents and you're not 100% sure, like, take a minute. And if in doubt, like, check the M274, go on I-9 Central, see if there's some type of information from a credible government database that allows you to make the decision, one way or another in order to make sure that you're not, kind of like blocking somebody out from the verification process and the work because of an unfamiliarity with a particular documentation or combination of documents, or because it happens to live, kind of like in a bucket that is listed. You want to make sure that, again, the employees know that they have the choice of documentation to present, don't over document, and then, kind of essentially like track the hard copy form when questions arise in electronic environments. And that's one of the reasons too that I, kind of flagged in the very beginning where you find that hard copy paper-based form, because for all of the technology that we have and all of the advances and all of the electronic options, from the government standpoint, this is first and foremost a paper-based process and a paper-based form. You are allowed to complete it electronically, but it's supposed to track, you're not allowed to do, kind of like freestyling of what the form questions are or like any of those things. It tracks, if you're using electronic process to create the form, it tracks the paper form. And, kind of if you're vetting a vendor or you're going through something and you're working with an electronic vendor, and you run into some type of roadblock that you think like, like, kind of like, what would this look like if I were doing the paper form? Think about that. And you want to make sure that you don't have a technology impediment that prohibits somebody from working when they should, because employers can get into trouble and they will be liable if there's some type of like unlawful limit in their electronic vendor. So sometimes electronic vendors also will try to do stuff and like drop down options and things that are intended to make the process easier, but you just want to kind of like, kind of keep your, kind of like eye on, kind of the idea of like, there are possibly limits and errors in your electronic system, and you could be in trouble if you blindly follow it. And I joke about this sometimes, like for those of you who have like watched the TV series The Office, and like, I don't know if you remember the scene that like Dwight and Michael, they're just like listening to their GPS and they like drive into a pond. They're just like it's telling me to do it. Like I'm blindly following. All of a sudden, like I am like submerged in water in my car. If you're working with an electronic I-9 vendor and you're just like, I think this is wrong, or this is a one-off, or something's happening, you always have the option to use a paper-based form for an employee that you think should be authorized to work. Employers can do a combination of paper and electronic. So, a really important takeaway as you're, might be in electronic I-9 or thinking about it is just like continue to be empowered, and, kind of like counsel your teams that there are options to deviate from the electronic if you think that maybe like the form has just not caught up to some new development or has some type of error, and kind of you're running through that process, because essentially this, kind of no matter what environment you're working in, it should, the process flow and the information, everything that's required should track that paper-based form. So, there are situations too, that you are, required to kind of re-verify employment authorization. So if somebody presents documentation for you that is, valid only for a certain period in terms of their ability to work, a good example is the employment authorization document card. That's a list A document. You have to, as the employer, you need to go back and you need to update the form to reflect that the person is still work authorized at the point that the document expires. Otherwise, you have to terminate their employment if they can no longer work. So, the idea is that if I give you a documentation that shows that I can work for a year, it's on the employer to be like, okay, like we're doing the I-9. I see that you can work for a year, but you have to follow up and make sure that that employment authorization has not lapsed with no, kind of future ability to work, and you can't like, kind of like think of it just as like one final moment in time that if they're work authorized on the point of hire, it lasts forever, because not all work authorization lasts forever. There are categories of individuals in the United States that are work authorized for a finite period, and it's on the employer to babysit that. So if you are in a situation that you have somebody that shows that they have work authorized for a period, the employer needs to have some type of tickler or tracking system where on or before that date, they check in with the employee and they say like, okay, like, the documentation we have on file that you have your work authorization expires on, July 1st. We need you to complete the updated section of the form to show that you continue to be work authorized. Again, on the anti-discrimination piece, and like I'm going to keep saying this, but it is really important. The employee needs to present the documentation. You have to give them their choice of what to present, because not all individuals who have one type of work authorization at the point of hire will have the same type of work authorization when you re-verify them, and that's okay. You might have somebody who at the point of hire they had a pending asylum application, and when you go to re-verify them, they have proof that their asylum application has been approved and they're now an asylee. Great. I might come to you with a temporary, kind of employment authorization document. And then in the meantime, I might be a foreign worker, but I have married a US citizen and I become a permanent resident, in the time between when I did the form and you checking with me to re-verify. So, I mentioned that because you don't want to be in a situation that if you have somebody who has become a green card holder or a permanent resident, that you're saying like, oh no, like you can't keep working because when you first started working, you gave me an employment authorization document, and now you're looking to give me an unrestricted social security card. Like it's, again, it's the employee's choice what to present. However, they do have to have proof of their continuing work authorization. So when you think about it, you're like, okay, like we're re-verifying their work authorization, not who they are. So if you're doing the update and the re-verification, you don't have to get another list B document that shows who we are, because we've already checked that off. You're at that point for the re-verification, you're checking in on a list A because that shows work authorization on list A, or an updated list C document that you would use to then re-verify. And then, you look at that document. If it expires again in the future, then you'd set another reminder to check in. So there are forms that you're going to be kind of like thinking about that are more dynamic, that you're going to have to check in with the employees and make sure that everything remains current. So in terms of the record retention, we talked, briefly, thank you for the question, and kind of where you can keep it. You have to keep them available for government inspection. So you kind of like you keep them on site and you're just like, all right, like I'm just gonna hold on to them and hope the government does not come. And if they come, you turn them over. So you keep them for a year after the employee leaves their job, and a minimum of 3 years. So if I only work for you for a very short amount of time, then it's the 3 year period that you keep them on file, because that's longer than 1 year. So you keep them for 1 year after date of termination, or 3 years from date of hire, whichever one is longer. So that's your universe. And that honestly, that is a little bit confusing. Like, even like, if I feel like I've thought about this for a long time. On one of the USCIS websites, I believe it's probably still there, but they do have like, they had like a little chart where you put in like, date of hire, like date of termination, like you can kind of see which one's longer. But kind of the premise though, and like the core requirement is that you have I-9s on site and on file for all of your current workers. So you're, kind of like, if you're a current worker, you've done the I-9, you keep it on site. And that's like, kind of like the government can check in at any point and be like, did you do the paperwork? Let me see your payroll. Kind of like, are the people who are here, are they working? And again, that protection piece of it, that if the government surfaces somebody's not work authorized and you have that I-9 on file for them, like you've done your thing, if you did it correctly, and that kind of the standard was met. You can never destroy the I-9 for an existing employee, no matter how many years have passed. Like, even if they've been with you forever, like if they're your employee, like it has to be on site, because this is like a real-time confirmation. Like, if you have somebody that's on your payroll and you're paying, you checked in with them, at some point, and you verified that they are eligible to be working in the United States. And the regs are like real weird and real old. And it says you can retain them on microfilm or microfiche, or electronically if you meet the regulatory requirements under electronics. So, like, like, oh, like microfiche, like this is like, this is what the regs say. They're like, oh yeah, keep your originals in paper, or oh yeah, you can do microfiche. Oh, for Pete's sake, like, that doesn't really make any sense. The thing is, like, okay, so you have your like your paper forms, you keep them on file, and they have the information that's in there, and then they have like the wet signatures, right? Those are your paper forms, and they care. They care from, kind of like from a possible future prosecution standpoint, like who signed that form. You have the signature, you can get a forensic investigator on site if, like, kind of like things are going weird. And we talked about, and this is outside the scope of this presentation. We're going to touch on it probably like in a lot more detail on the final presentation, when we talk about like preparing for site visits and on-site. But like, there's stuff that can kind of like spin off the I-9s. So employers could be charged for like a harboring, kind of people who are not supposed to be here, because they don't have, they're undocumented. You can be charged for, racketeering. You can charge for, if you have you can think about like kind of like how things can go wrong if you have a, kind of a very bad actor that is, kind of like employing people, like creating fake documents, making them come on, like like recording those documentation, and then like, kind of abusing their workers. Like, that's a big deal. Like, who created that form? Did the employee sign the form? Did the employer? Like, we care about who signed the form. You retain it, you keep it on file. The regs say microfilm or microfiche. You're probably not going to be doing that, or electronic retention under the regulatory requirements. And as soon as you move away from paper, you are kind of like jumping into this other section of the regs that talk about what employer obligations are for electronic record retention. And they have a number of things that we're going to talk about in more detail in the second of these sessions, like next week. But they, kind of as a preview, you have to meet certain security standards. You have to be able to index them. You have to be able to show that there's an audit trail, kind of again, who did what and when. Because when you're moving away from the paper form, they're like, okay, this can be electronic, but we really have to have a high level of tracking and be able to get. And also, there's a lot of personal identifiable information on the form. We want to make sure that these are secure, and that the government, kind of can get to them, in that they're, kind of like they're stored, under the regs. The regs are kind of confusing. They were written to be kind of confusing because they were intended to be kind of broad enough that it withstands changes in technology. We'll talk about that. But, essentially, like, you do the form and you keep the form. You do the form, you keep the form, and then you give it to the government if the government asks for it. What does it look like if the government asks for it? I put this link on. There's a fact sheet on the ICE website. You're working at that point. Like if the government comes, it's going to be somebody from the Immigration Customs Enforcement. This is something that we'll talk about in the final presentation. In a deeper dive around, kind of what a notice of inspection would look like, what they can come and do, what they're looking for. But you're, essentially like, all right, like, we have to have the forms. They're required to be retained. This is an administrative process if it's an I-9 inspection, and the government comes with a notice of inspection that it is authorized to give under the regulations for the Form I-9. So this is something that, like, it's a law that you have the forms, you create the forms, you retain them, and you give them to the government. So they actually don't necessarily need a warrant or a subpoena to ask you for the forms. It's a notice of inspection. If the government comes, you have at least 3 business days to produce the I-9s requested in the notice of inspection. So it's not something that's like, house on fire if they come drop it off, because you don't have to like turn it around. You shouldn't waive that period. We're going to talk about some of those best practices. And that the government, when they come, it's a subsection of ICE, the Homeland Security investigations. They're going to want, some additional information too. So they're basically going to look at it and they're going to say like, okay, thank you for your forms. I also want your current payroll record so that we can compare it. So they're like, if you have like, 3,000 people on payroll and you turn over like 30 forms, like that's a problem. If you have like 100 people on payroll, they want to see 100 forms. Sometimes they'll ask for the forms for people within the retention period, sometimes they don't. And then they look at them. And if, they find technical or procedural failures, that the employer receives, a period of data to make the correction. So, kind of again, we're going to talk a little bit about corrections on the next slide. This is actually kind of like, again, I did not get into like graphics and things that I think is kind of, it was so Sonny Bono, the singer from the 70s, like when he became a congressman, he created an addendum that said like, like not all errors on the I-9 are created equal. So if an employer has like a little boo-boo on them, like so say you forgot to write in, like so say you like wrote in like, kind of like your birth date on the like the like, kind of the wrong section, or like, you forgot to check a box that was not a substantive violation. And unless it's a pattern of violation, employers are supposed to be able to fix the form and not be fined for like the little things. It's kind of like for those of us who are like from the Catholic Church, like our mortal and venial sins, like not all of the errors are created equal, so you are able to fix some if they see them. The big things like not doing the form, like not having stuff, signed, like those are substantive violations. And you're not going to be able to fix those. Those are going to come straight if they decide to fine you. So, that's what it looks like. So you keep it on file, and then, kind of you just keep them on file until the government shows up with a notice of inspection and says like, I'd like to see your forms, and you've got 3 days to turn it over. If you use an electronic system, they're going to want to know details about that also. They're going to ask about the form. So, kind of thinking through this, and I have, kind of some other things to think through. In the kind of the remaining time, we're going to have about 15-20 minutes for Q&A, and I will just keep talking if nobody has any questions. But as we're thinking like going forward, like this was really intended to understand the basic process requirements, because you can kind of see how easily something might just kind of like slipped through the cracks, and then like you have somebody that is responsible for your I-9 compliance, and they think like you have 3 days to complete section 1. You think that you are doing like a good job by asking for more than necessary or making it easy, and you're kind of like at risk for discrimination at that point. You're writing down everything on the form. You are maybe like not tracking the re-verifications. You're not using the current form version. At this point, this is a good opportunity to just like get down to basics. Understand the basic process, because having a basic process understanding gives you a very firm foundation for doing other things like vetting electronic I-9 vendors, identifying issues if there is one with your electronic I-9 vendor that you're using. Kind of like fundamentally what the government really, really cares about is like, are you doing the process, and are you verifying that your employees are work authorized? That's the people aspect of this. And there is liability, civil and criminal, for not doing that right. That's the, kind of we're doing this because we're looking to prohibit people who are not able to work from working. That's the big piece of it, and that's the kind of the core piece of it. The other thing is like, all right, you're doing it, but how's your paper look? Like, are we, kind of having errors, like all of those things. It's a different fine structure. And that's, kind of like, that's the second piece of it. But like, understand the basics, go over the form, read the instructions, kind of go through all of those. And you're looking at that and, kind of like, just understand your timelines and requirements. If there is a notice of inspection, where are your forms? Can you get them? And how would you be able to produce them? So going back to the prior question, can you keep them off site? Like, yes, you can, but don't keep them so off site, like in some document storage, like, kind of like facility that you couldn't get them if within 3 days, if you need to turn them. And also just kind of like, think about, like kind of like, all right, what do your forms look like and what have they looked like since the 80s? Like I like, I like it, like I do think it's really interesting that this was like from the 80s and like think about our lives. Like I am like older than the I-9 and like I saw my life and the analogy that I think about it, and I said this and I don't think I can't remember if I said it in the presentation, but like it's like so like when I think about it, I think about like how I used to take pictures like for like a long time like my pictures they are all in hard copy, everybody's were, and then they kind of evolved and I started doing some digital and I kept like some of my digital pictures like on an old computer and then some of them are in a jump drive and then some of them are here and then like now they all live on like a much more like advanced electronic system that's sitting like in my phone, and that's a different animal. A lot of employers are kind of in the same boat. Like you probably have like your older employees that have been with the company forever have paper forms. Where are they? Can you get them? What do they look like? Was there a period that somebody was like just not doing forms like that? Like you want to know that. Like, was there a period that somebody was doing them and you were using like an electronic on vendor? Did somebody at some point PDF all your paper forms? At that point, like you'd want to be ready to be able to show that that PDF was digitalized, that you are meeting the requirements of your kind of electronic retention, regs, and that applies. And then if you were in, electronic vendor one and then you switch, like, can you get your audit trail from that old vendor? What's going on, kind of with your new vendor? Do you know where to get the audit trail from that? Like, so think about, kind of like at this point, like understand the basics, find out where your forms are, and then kind of see where you are. Think about your assessment. Consider a self audit. It could be like a spot audit, to identify some of the issues. It could be more comprehensive. Know your strengths and weaknesses, kind of like, when, kind of when was there a lapse, kind of like, is kind of, is your electronic I-9 vendor good? How would you communicate that if you have that? Find your forms. If you are doing an audit, you're making corrections, it's really important that it's not something that looks like it was like, trying to hide the ball and making the correction. Any correction needs to be very clearly made on the face of the document. So if I'm going back and I'm creating a new form, I'm dating it in real time, but I'm using the initial date of hire. If I'm going back and I am like, kind of correcting something, I am like striking through it in a different color pen and I am like writing in the right date and I am initialing it. It needs to be very transparent. You never want to be a situation that you are like whiting anything out because there's a presumption then that you're looking to hide something. Errors can be corrected. It's important to do so, especially in the self audit. It might, be able to start that statute of limitations, and it might be able to kind of like, lock in liability. But it's very important that it's clear. And then you want to conduct the audit and then you follow up in a non-discriminatory manner. Create a plan. Like don't start with individuals who have foreign sounding names. Like don't like, kind of like follow up with some in a manner that's different than others. Kind of think about it that you're, looking to avoid discrimination in all aspects of your I-9 process, including the hire and also the follow-up. So we have some common questions and issues that I, kind of like just wanted to hit on. I wasn't sure how long the presentation would take. So, you're probably kind of amazed that we've gone the whole way through like over an hour of just like I-9 basic stuff. The stuff that we're going to talk about in more detail in the next presentation is, a deeper dive in electronic systems. We're going to talk more around E-Verify, what that looks like. We're going to talk about the electronic kind of verification process and the kind of like the pros and cons for that. We're going to talk about the virtual alternate review process, which you can do in like what the conditions of those are, and then some of the like more advanced issues around all of those. For the basic one, I wanted to touch on, a question that comes up a lot, to copy or not copy documents. So if I'm an employee and I am, kind of like presenting my documents to you, do you keep a copy of it or not? This is also a consideration that you'd want to think about from a discrimination standpoint. one thing that you wouldn't want to do is copy documentation for some people, but not others. It's not required for the process. So if you are not in E-Verify, which does trigger some document copy and retention requirements, if you're not in E-Verify, you are not required to copy the documentation. The reasons not to do it would be if you have any if you're doing I-9s in a situation where you just don't have access to a copier, so maybe you are you have a business model where you're doing on site for people who are, kind of not coming into the office right away. And you don't want, kind of the person that's doing the forms to be taking pictures of their social security card on their phone, and kind of protecting the PII is a really important consideration. If you're in the office and there's a question of to copy or to not copy documents, you can do it and securely, kind of retain them. Also, there's a benefit to copying them. One of them is that if you're in a situation where you've completed the form, but you're missing some of the fields, but those fields appear on the document copies, that moves it from a substantive to a technical issue. So if I had presented to you my driver's license and you wrote driver's license Maine, but didn't write the document number, but you had a copy of my license underneath it and that had the number on it, then you could correct it, but just based on the document copy without calling me back in because you have the record. So it's really going to be a case by case. So if you do it, you want to do it non-discriminatory. And one of I think the key factors is just how are we getting the documents? And do we feel comfortable, especially given the amount of PII on the social security cards, the passports, all of that, how they're being retained. E-Verify is a supplement to the I-9 process. We're going to talk about it in section 2. It's, kind of an online system that is voluntary for most employers. If you are a certain federal contractor, so if you have a federal contract that has what's called the FAR E-Verify clause in it, you are required to use E-Verify. If you are in certain states, or local areas, there might be state-specific E-Verify laws that you have to follow that are important to track. Maine does not have a E-Verify law right now, so in most cases it's voluntary. There are some programs that are kind of incentivizing E-Verify use. If you want to, for example, extend a F1 student status, you have to be an E-Verify employer. E-Verify is a condition for you using the alternate document virtual review process. We'll talk about that next time. I did want to flag, and you can tell I felt very strongly about this because I put in all caps. You don't re-verify a lawful permanent resident document unless the document was a receipt. And that's kind of confusing, but you can get in trouble for doing it. Lawful permanent residents or green card holders are US workers. And even if the card's going to expire, but the card expires like a passport expires, it's kind of confusing. Sometimes the lawful permanent resident card will be only valid for 2 years and it'll say conditional permanent resident. You still don't re-verify them. If you have a lawful permanent resident, you do not re-verify them or you can get in trouble for discrimination. Be mindful about going above and beyond. Like we talked about, don't be a hero and kind of ask, if you're hiring Patrick, ask him for A, B, and C. You're going to get in trouble. I actually did put trust but verify. Now you know what it meant. I wasn't sure what I thinking about doing it. Questions come up for rehires and re-verification. Check the M274. Your reasonableness standard applies to name changes also. And there are some tricky situations where somebody has presented false documents but later obtained status. Think about it affirmatively. Do you have an honesty policy? Is that something that kind of you look back and try to enforce? There's guidance around an M274. So those were my questions, and I can do a deeper dive into any of those. And I have a couple other things, but Patrick has hopped on, so I'm going to take a little breaks in case Patrick has any questions or wants to flag, or in case he's just all right, we're done. I'll turn it over
Thank
to
you so
Patrick.
much, Katie. Take a breath and a sip of water. Such a great overview of the I-9, new world for me. We do have a couple questions in the chat that are fairly specific. I did, just to start at a high level before we get into those two questions. Um, you mentioned, I think we have an understanding that there are sometimes violations that are willful, that are clear, that we hear about. Going through the best practice, can maybe flip it on what are some of the typical violations that actually get into enforcement that maybe are not so willful, but maybe we're a little bit more on the sloppy side.
Yeah, I mean, there's sections of the form that are easy to miss. So if you're going through it, very frequently you'll have people that kind of might put their, kind of this today's date and the date of birth field, on a prior version of the form, they had did I use a translator prepare underneath the employee signature line, that was easy to miss. A lot of it is just, kind of I think just, running, as the HR, kind of onboarding process is just a million miles an hour that you're just like, oh, here's this form, like, let me just fill it out really quick, and lack of attention to kind of like reading in section 2 the whole way across all the fields, issuing authority. And it's intuitive, you're just like, well, I don't know, it's a US passport, like, who do you think issued it? But like, fill it out, like, just, kind of like trying to move quickly, I think is one of them. People frequently forget to put the date of hire in the form. And then I do think that the discrimination piece of it is, something that, kind of like is not willful. And the way that the Department of Justice treats it is they don't care why you treated somebody differently. They care that you did treat somebody differently. So just making sure that you have a very standard practice for everybody. I think that's a very, kind of like easy way to get into trouble, because the way they view it, there's not an intent. You don't have to have like a negative animus on it. You just have to have treated somebody differently. So that's something that's very important to kind of keep an eye out for.
Katie, that was my second question. It's sort of interesting in this discrimination standard at a time when there's a lot of uncertainty for authorizations going forward. For instance, an individual who's authorized to work now but may have uh, asylum authorization for a certain period, but it may expire. Can you kind of comment how that applies in if they're applying for a job, they are authorized to work, but there may be uncertainty for their future
Yeah.
work authorization, how that applies?
Yep. This is very difficult to navigate for employers. And we're gonna talk about this in a lot of detail. And I'll just, I'm gonna answer your question. I'm gonna answer it again, in section 3, because this is really hard. So when you're doing this process, there's, kind of in most, what you want to do is you want to treat everybody the same in the application process, right? Because you just don't know. So when you're applying, your application material should have a question on your application form that says, are you employment authorized to work in the United States? Kind of like yes or no. So that's an initial screening question. And then, a lot of employers, if they're looking to kind of like be mindful that, kind of they don't sponsor certain workers, or they might have a need that would exceed the duration of a particular, kind of employment period, they'll ask a follow-up question that says, to work in the United States, do you need sponsorship now or in the future? And sometimes that's a way in the hiring process to identify somebody who has work authorization for a certain period, or that might, kind of like be at risk, and articulate to you that sponsorship may be required. And then the employer can kind of like navigate that and make certain business decisions in the hiring process on how to do that. If you have somebody that is, kind of like not communicating around that, and you go to the point of hire and you're doing that I-9, or you have them on your workforce, then you're, kind of, you're going to want to be careful. You're not going to want to reject somebody out of turn just because of the classification they're in if they are work authorized. At the point of doing the I-9, if you have somebody who's valid for only for a period, you might say to them, under federal law, I am required to re-verify your employment authorization. I see that you expire in 4 months or something along those lines. Do you anticipate being able to provide, I'll take any documentation of your choice. Do you anticipate being able to provide, ongoing work authorization? And if they say yes, then at that point, like I would recommend against, kind of terming them just because the documentation expires. There is one state, Illinois, so if anybody's on this call that has, kind of multiple states, there is one state that actually has a law prohibiting against, kind of rejecting somebody because they have a document that has an expiration date. And there are, laws aside from the I-9 laws and rules that could get employers in trouble if they bounce somebody because of their classification for worker, or their upcoming expiration date. So for example, if several years ago there was a class action under a civil rights law that Procter & Gamble took a position early on in the Deferred Action for Childhood Arrivals program, where they said, we're not going to hire any DACA beneficiaries because we think this program may go away, and we don't want to train people, that are going to lose their work authorization and bring them on site. That was a class action under, civil rights laws. So, I think just it's to your point, it's being mindful of, kind of just like navigating that. And kind of we're going to go into a lot of detail around this in the next one. For your current workforce, there are people who are losing their employment authorization that they had at the point of I-9 in periods faster than they anticipated because of changes to federal law, like termination of temporary protected status, specific actions taken about for individuals who were paroled into the United States. My advice is from the employer standpoint, if you did the I-9, you've done your thing, you re-verify them on schedule. But if you get actual or constructive knowledge, then you would re-verify possibly earlier. Like, I don't think any employer has to babysit like every single Federal Register notice out. But if you do, then you're going to kind of start stepping into that knowledge base. So, it's a very chaotic time in all of this, but you're, kind of just to kind of like boil it down, you do the I-9, it's a moment in time, you get work authorization for this period, and then, kind of like you continue to kind of chug along, but you kind of step into the I need to touch the form again or check in if you at any point get knowledge that somebody is not able to continue to work, because that goes into the bucket of being concerns that you have continuing employed somebody that doesn't have authorization. So that's a layer of it that needs to be kind of managed, post I-9. But this is, kind of like, I'm not going to say these are unprecedented times because that reminds me of COVID and that stresses me. Everybody used to say that, but these are chaotic, and we're going to talk about a lot about that in the third session, because the goal for employers is compliance, and you're kind of you're doing the best you can. So it is very difficult.
I was intrigued by your suggestion on doing a self audit, and how that maybe intersects with doing a re-verification on intervals. But just so I'm aware, is a self audit usually conducted by a third party, or is that something you can do internally?
You can do internally. Usually you'd start internally. Like, you can check in, kind of like with third parties if you need help. But one of the questions in the chat, and I like I'm not gonna check on Answer Live because there are names on here. And I think if I answer live, I think it shows everybody in attendance who asked the question. But the question is, I audited my book. I found I-9 for somebody who was hired in 89 and the employer section was not filled out. How do I get that corrected? I can tell you that I think like the stats are something like on paper I-9s, I think there's like a national average of like 75% error rate in some way on most of the forms. Like, there's a lot of like, and that's one of the benefits for, kind of like, kind of using electronic, there's other considerations that we'll talk about next section, but like it's harder to make the paperwork errors. If you do for example, if you look at your books and you're just like section 2 wasn't filled out, then it's better late than never. So then at that point, like, you take, like, I'm the employer, I looked at this and I was like, oh, for Pete's sake, like, kind of like Joe Smith, kind of like was doing a real bad job in the early 90s. Like, Joe never signed it, Joe never did this. Then you get the new version of the form, and then you pull that new version and you sit down with the employee at that person and say, like, we're doing a self audit. Our goal is compliance. Like, we looked at our forms, like there was an issue with your form, we're going to use the real version, and then you do it in real time and you attach it to the old form. So in the self audit, it's kind of like you're looking at it and then you're trying to fix what you're seeing on your forms. And kind of there are some best practices, and we'll talk a little bit more in that in like a section about kind of like kind of creating a file memo that shows that you were doing an audit, that can show good faith, because like we talked about, there's a range of penalties, and kind of like you're going to be on the higher end if you're not trying. You've got a lot of forms, like they'll factor in the sophistication of the employee, or like several things, but it can be a positive factor of doing a self audit, and just trying to clean it up, so you kind of like it, to answer the question, if section 2 is missing, then you grab the new version of the form, you sit down with them and you say, like, all right, we've got to look at your documents now and sign off on it.
Just a few minutes left. There are two questions I think you addressed perhaps one open one, but I see two questions if you might be able to address those before we conclude.
Sure. So there's a question about rehiring for people that come back. And when you rehire somebody within 3 years of the initial I-9 being completed, you have the option to just create a new Form I-9 for them, or to, kind of like look at their forms and then like sign off on supplement B and say, like, rehire and check in, like, and re-verify only if their employment authorization has lapsed, from the initial one. So, I, with only a couple minutes left, I would say, look at the M274. There's a section about rehires and re-verification. So, I would do what makes the most sense for your business in terms of saying, like, we're just going to create new forms across the board. That's easier. Or, in the rehire, kind of doing a, kind of a review of the forms on file within that period, and making the update. And then the other question is including copies of the docs. I think it's a business decision. It's a kind of a good practice to be able to show what they presented if there's a question of whether the documentation was valid. And like I said, in some cases you can kind of like update the form if something was missing, if you have it on file. It's totally fine to have I-9s without copies of the acceptable documentation. It's voluntary to do it. You just want to make a decision rule and be consistent whether you're doing it or not. And if you're an E-Verify employer, you do have to keep copies of certain documentation because there's like a photo match piece of it. So, kind of that's something that would be a little bit of a different answer depending on if you're in E-Verify or not. And if you're missing I-9s for certain employees, you have to create the form in real time. So you'd put the hire date, as the actual hire date, and then you put the completion of the form, because essentially for the I-9 and all this stuff, you can't go back in time. Like, we cannot go back in time and redo something. Was better late than never in terms of doing it. But one, kind of just closing thought in the self-audit is like, if you do the self-audit, you find all these issues, you have to be ready to fix them. So you want to kind of like, you don't want to be in a situation that you've identified a whole bunch of problems and then you're that's going to be a negative inference if the government finds out about that. But you want to just kind of like be ready, if you think you're missing forms, to then start to like schedule meetings with people. And we can talk in one of the default presentations about kind of like what, kind of like what that would look like, how some best practices for communicating around an audit, like following up. I'll put that on the agenda for next week. And it's 10:30.
Katie, thank you so much. That is a lot of information. I think it's extremely valuable. Please join us next week as we go to a little deeper depths of E-Verify and more sophisticated implementation of the I-9 form. Katie, thank you so much for your comments, your insights in a hugely timely topic for employers across the state.
It was my pleasure. Thank you for having me. And thank you for all the people who joined and stuck with us for 90 minutes of I-9 talk.
Thank you, and see you next week. Take care.
Thanks.